You're watching Court in 4K.
Is Drake actually suing Kendrick Lamar? Man, hell no. Ask the internet and you will hear the opposite. You will hear that Drake got his feelings hurt in a rap battle and ran to a courthouse to sue the man who beat him. That is the version everybody repeats. It is also wrong. And it is wrong in a way you can check in about 90 seconds. Because lawsuits are public and they have names on them. The name on the other side of Drake's lawsuit is Universal Music Group, the record label. His own record label, the one he had been signed to for 2 decades. Kendrick Lamar's name does not appear on it as a defendant. It never has. We are not here to pick a winner in a rap beef. We are here to read the paperwork. And the paperwork is stranger than the story you have been told. Set the table first. Spring of 2024. Over 16 days, Drake and Kendrick Lamar released 8 diss tracks at each other. 8 in 16 days. That is not a feud, that is a full-blown war. The federal judge who eventually handled this case described it in her written opinion as, quote, perhaps the most infamous rap battle in the genre's history. The second to last song in that exchange was Not Like Us. For some, that won the argument, but what it did for sure is win a Grammy and get him a Super Bowl halftime spot. It also contains lyrics accusing Drake of being a pedophile. Here's the part that catches people off guard. Both of these men are signed under the same corporate umbrella. Universal, through its publishing arm, holds rights to Kendrick Lamar's music and to Drake's music. Same building, same machine, same people cashing the checks on both ends of the war. So when Drake went looking for someone to blame, he did not aim at the man who wrote the verse. He aimed at the company that pressed it, promoted it, and profited from it. His first move came in November of 2024, and it was not the lawsuit everybody remembers. Drake's company, Frozen Moments, filed what is called a pre-action petition in New York. Think of that as a legal fishing license. You are not suing yet. You are asking a court for permission to go look inside somebody's files first to find out whether you even have a case worth filing. What was he fishing for? He alleged that Universal and Spotify had juiced the numbers on Not Like Us. Bots, payola, discounted licensing fees, paid influencers, the whole menu. Universal's answer was one sentence, and it was ice cold. Quote, the suggestion that UMG would do anything to undermine any of its artists is offensive and untrue. Spotify answered that December of 2024, calling the claims false and the whole proceeding, quote, a subversion of the normal judicial process. They added that Spotify and Universal, quote, have never had any such arrangement. Then on January 14th of 2025, Drake withdrew the petition, dropped it, no cost to anybody. The very next day, he filed something much bigger. January 15th, 2025, federal court in Manhattan, Graham versus UMG Recordings. 3 claims, defamation, harassment in the second degree, and a violation of Section 349 of New York's General Business Law, which is a consumer protection statute, a law meant to stop companies from deceiving the public. The case landed in front of Judge Jeannette Vargas. Now, defamation, this is where the case lives and dies, so let's be precise about it. To win a defamation case, you generally have to show somebody made a false statement of fact about you. That word fact carries all the weight. Opinions are protected, insults are protected, exaggeration is protected. If I say you are the worst driver in America, I have not defamed you, because nobody hears that as a finding. If I say you were convicted of vehicular manslaughter last Tuesday, that is a factual claim, and it had better be true. So the entire fight came down to one question. When Kendrick Lamar made that accusation on a track in the middle of a rap battle, was a reasonable listener hearing a statement of fact? Or were they hearing a man throwing the hardest punch he could find? On October 9th of 2025, Judge Vargas answered. She granted Universal's motion to dismiss in full and close the case. Her holding, in her own words, quote, because the court concludes that the allegedly defamatory statements in Not Like Us are non-actionable opinion, the motion to dismiss is granted. Non-actionable opinion. 2 words that mean you cannot sue over this because it is not the kind of statement the law treats as a fact in the first place. Her reasoning came down to context. The songs in that battle she wrote were, quote, in dialogue with one another, and they, quote, must be read together. You cannot pull one bar out of an 8-track shouting match and grade it like a news report. On the song itself, she wrote that Not Like Us is, quote, replete with profanity, trash talking, threats of violence, and figurative and hyperbolic language, all of which are indicia of opinion. Translated, the whole thing is so obviously an attempt at a verbal beatdown that no reasonable person mistakes it for reporting. And the line that ended it, quote, a reasonable listener could not have concluded that Not Like Us was conveying objective facts about Drake. Sit with what that does and does not say. The judge never ruled on whether the accusation was true. She ruled that the law does not let you sue over it. Those are very different things, and almost every headline blurred them. Drake had a fallback. He argued that even if the song was protected opinion the day it dropped, once it became a monster and Universal kept pushing it, that changed things. The judge was not moved. Quote, whether publications constitute actionable fact or protected opinion cannot vary based upon the popularity they achieve. Constitutional guarantees do not rest on such a flimsy foundation. She called the theory, quote, logically incoherent, and added that republication, quote, cannot transform Lamar's statement of opinion into UMG's statement of fact. Plain version, a song does not become defamatory because it went platinum. Now the streaming claim, and this is where we are going to be fair to Drake because most coverage was not. Drake's proof was not nothing. He pointed at a song that reached 300 million Spotify streams faster than any song in history in 35 days. He alleged Universal paid influencers, cut licensing deals below market to get the song placed, and leaned on business relationships to push it. He alleged Spotify was steering users who searched for completely different artists toward that record. And he made an argument that lawyers make all the time. The receipts for a scheme like that would sit inside Universal's own files, not his, which is exactly what the discovery process exists for. Discovery is the stage where each side has to hand over its internal documents. He was arguing he could not prove the inside of the machine without being allowed to look inside the machine. We are not picking sides, but that is a compelling argument. The judge still said no, and her reason was about proof, not truth. To get past this early stage, a complaint has to be plausible, meaning you plead actual facts, not suspicion. What Drake brought to support the scheme was what she called, quote, unreliable online commentary. And she said he failed to offer facts that would make it highly plausible Universal ran those tactics. She even used the phrase, quote, if they exist. Read that carefully. That is not a finding that nothing happened. That is a judge saying you brought me screenshots when you needed documents. She also killed the consumer protection claim on a second ground. That statute is about harm to consumers, and she found none pleaded. Quote, at most, the allegations suggest that UMG engaged in practices to make Not Like Us seem more popular than it actually was, without connecting that activity to any consumer harm. So where does Drake actually stand right now? He appealed. The case sits with the United States Court of Appeals for the Second Circuit, the federal appeals court above Manhattan, docketed at the end of October 2025. 3 judges there can leave the dismissal alone or wipe it out and send the case back to life. His argument on appeal is bigger than his own reputation. He says the trial judge created a categorical rule that statements in rap diss tracks can never be statements of fact, and that a rule like that is dangerous because it hands a permanent shield to anyone hurling accusations as long as they rhyme. Universal says the opposite, that protecting the diss track is protecting hip-hop itself. This is not just the two of them arguing anymore. A Free Expression Institute and a group of legal scholars filed briefs weighing in. Outside parties do that when they think a case is about to set a rule that will bind everybody else. That is a signal about the stakes. As of right now, the appeal is fully briefed and waiting. Drake's reply brief went in during April of 2026. There is no decision, and there is not even an argument date on the calendar. So what actually turns on this? If the dismissal stands, a diss track becomes close to untouchable. Put the worst accusation you can imagine over a beat, and the law treats it as trash talk. If Drake wins the appeal, every label in America has to start thinking about what it distributes and promotes because the shield gets thinner. Which means the biggest question in this whole saga is still open. Whether a court will hold that a rap lyric, no matter how specific and no matter how damaging, is always just an opinion. 3 judges in Manhattan get to answer that. And whichever way they go, every artist with a microphone and a grudge is going to read it very carefully. Every case, every charge, every update. We don't miss. Caught in 4K.